Order, order. Welcome to today's meeting of the Joint Committee on the National Security Strategy. This is the first evidence session into our inquiry into espionage cases and the Official Secrets Act following the collapse of the case involving the alleged spying activity for China. Our objective from these sessions is to bring clarity to questions that have arisen in recent weeks, to ensure proper accountability and review the adequacy of processes and decision-making. It's unusual for us to examine the details of such a case, but it is warranted given the scale of public concern. So we're going to be hearing from officials today and ministers on Wednesday morning. I'd like to remind witnesses of their obligations to Parliament and the expectation of providing as complete answers as possible. So perhaps I could start by inviting those present just to introduce themselves.
Thank you, Chair. My name is Stephen Parkinson. I'm the Director of Public Prosecutions.
I'm Tom Little, KC, First Senior Treasury Counsel, and was the instructed advocate in the case that's the primary issue of your concern.
Thank you. Stephen Parkinson, the situation we find ourselves in is quite extraordinary. Who do you think is responsible for the collapse of this case?
First of all, Chair, may I say how disappointed I am that this case could not proceed to trial. I recognise and absolutely endorse the points that you have made about the nature of this case, and in particular the level of public concern. And I'm very conscious indeed that there were two victims in this case who were members of the House of Commons, who were the victims of a gross breach of trust, as was Parliament itself. In terms of your question, if I may say so, I don't think it is a question of blame. The responsibility of prosecutors is to place cases before the court on the basis of sufficient evidence to secure a conviction. And ultimately, the issue in this case is that we were not able to provide the evidence to sustain the case in respect of one essential element, which was the element that China was an enemy, as was required by the statute.
Do you think on that point, do you think there was or did you ever get the feeling that the government wanted this case to fail? Nothing
reached me. I should, I'm sure it's known to many members of the committee, but if I may just explain the division of responsibilities in terms of criminal cases. So we don't investigate cases. We look at the evidence and we make decisions about whether it meets our tests. But the relevance of this to your question is that until a very late stage, we weren't engaged directly with any witness. That was the responsibility of the police. So I do not know anything about the background to the statements that were produced. Our responsibility was to look at the evidence, to ask investigators to obtain more evidence, if that was possible, and then evaluate whether our tests were met. And the key test for prosecutors is the evidential test, which is there a realistic prospect of securing a conviction?
So you felt that you didn't have the evidence that was robust to put before a jury?
We did in the first instance.
What changed?
What changed was the ruling in a case called Rusev, which imposed an additional requirement. So, as I've explained, one of the elements of the offence was to establish that China was an enemy, and our route to doing that was to frame a case on the basis that China was a threat to national security.
Or an active threat?
Well, at the time, a threat. The difference that Rusev, which was another case based on the same prosecution theory, in fact, of threat to national security, there was a ruling in that case which said that you can mount a case on the basis that, in that instance, Russia is a threat to national security, but you have to show that at the material time it was an active or a current threat to national security. So the statement that we had at the time in our case didn't go that far, so we asked for confirmation that at the material time, which was the dates of the offence, China was an active threat to national security. That we did not think that this would be a difficulty, but in the end it proved to be a sticking point and we were unable to secure that evidence.
When you decided to drop the case, what advice did you take before coming to that decision?
Well, there was an enormously experienced team involved in this case, comprising internal lawyers, very experienced in national security cases. Mr. Little, who sits on my right, was involved at the outset and was trial counsel. So we had advice from Mr. Little, we had internal discussions, and then the way these things develop with complex and sensitive cases in the Crown Prosecution Service, senior people have to be consulted. That happened as well. And a decision was taken, which ultimately I endorsed, that we would not be able to meet our test, that there was a realistic prospect of a conviction.
And at what point did you decide that there was no alternative charges that could be pressed? Given the challenges that we'll come on to in a moment, but at what point do you decide there was no alternative charges that you might level at these two, such as plotting to or planning to commit espionage or any other similar legislation?
Well, all this was in the mix, really, at a point at which we concluded that we could not prosecute the case, and that was late August of this year. If I may, perhaps I could just bring in Mr. Little at this point, who was closely involved in advising us on the issue.
So just dealing with a couple of matters that you've raised, perhaps to try and join up some of the dots. The critical meeting, which was an unusual situation for leading counsel for the Crown to meet a witness in these circumstances, and I did that on the 14th of August, and I have a very clear recollection of that meeting because I needed to understand why the two previous attempts to get statements, statement number 2 and statement number 3 from Mr. Collins, why, as it were, what I thought would be relatively straightforward to be said, which was there was an active or current threat to national security, why that hadn't been articulated in clear terms. I also want to make it clear I was not concerned if the witness didn't use the word enemy. That would be a matter for the jury. But I needed to have the evidence to support the submission to the jury. And the witness was clear to me that he would not say that China posed an active threat to national security at the material time. That was in answer to what I regard as the million-dollar question in the case. And once he had said that, the current prosecution for those charges was effectively unsustainable. That's my carefully reflected position. I didn't jump to that immediately. I advised on the 22nd of August, having reflected over it as far as those charges were concerned. There was other discussion then about alternative charges, but I don't think anyone should misunderstand the effect of what the witness had said. That would have been disclosable, and it brought this case effectively to a crashing halt as far as that was concerned with that witness, who is the Deputy National Security Advisor to the Cabinet. It's very different to the position of giving away a witness who witnesses a criminal incident on the street for reasons that I hope are obvious. But we did give very careful consideration as to whether this was remediable. And I concluded, but more importantly we concluded, that is the entire prosecution team, that it was not.
Okay. What do we mean, Dame Emily, but just briefly, if I could, Lord Hutton.
Yes, a question really for the Director of Public Prosecutions. You said in your opening statement to us that you were disappointed that
Yes.
this prosecution couldn't be brought. And it sounds like you think that there was enough evidence, clearly, to merit a prosecution and a reasonable chance of conviction. And your argument is purely that the Rousseff case changed that.
Essentially, yes. I mean, I was disappointed. We felt that we had a good enough case to prosecute. We'd obviously spent an enormous amount of effort getting the case to the point that we did. And we felt that there should be no difficulty, in fact, in answering the question that we posed. Was China an active threat to national security at the material time? We thought that would be evidence that could be given relatively easily, but it turned out to be a sticking point. We first asked that question, so the ruling in Rousseff came out on the 31st of May 2024. We asked that question on the 11th of June. We slightly amended it the following day. It took 14 months to get the answer to that question, and the answer was no. And it took quite a lot of effort on our part to try and get the answer. But what you can't do as a prosecutor is tell people what to say. You can only obviously ask questions. But we did put a lot of effort into it, and yes, we did feel disappointed and frustrated. This was an important case.
Did it ever sort of occur to either of you that, given that if this case had gone to a trial, a jury would have had to have decided what the threat to national security was? And many people, certainly in this place, would think you can't have national security without economic security. And the Deputy National Security Advisor was very clear of the active threat to our economic security that China posed. And neither of you felt that that was sufficient basis to put an argument to the jury that that in itself could have constituted a threat to our wider security interests.
The question that was posed was, at the material time, was China an active threat to national security? The answer we got with the second statement was it was a threat to economic security. So the question wasn't answered in terms. But if I can just really reiterate what Mr. Little has said, the issue wasn't so much the statements that we were given, it was what was missing. And the key question which would have been posed in cross-examination was the question that we posed in June. Was China an active threat to national security at the material time? And the answer was that confirmation couldn't have been given. Now, can I just explain the impact of that? So the way criminal procedure works, the prosecution lays out its evidence before the court, and at the close of the prosecution case, the defence are entitled to make a submission of no case to answer. And they can do that if any element of the offence is not satisfied. And if the judge concludes that no reasonable jury properly directed could reach that conclusion, then he will stop the case. And the conclusion that was reached by Mr. Little and by our team was we were in that place. So this case would not have got to a jury because our professional assessment was that we were unable to satisfy that limb in view of that answer. So it's not so much the evidence that was given, it was that answer went to the heart of the issues and it was fatal to the case.
Can I
just add?
Just bring in Dame Emily.
Can I just may I just because I think there's quite a lot of elements here that let's May I do it this way? Let's start with the evidence that you first had to charge Berry and Cash in April 24 with under Section 11C of the Official Secrets Act. What you had to prove was there was the actus reus, the guilty act, which was communicating information that might be useful to an enemy, and the guilty mind, the mens rea, for any purpose prejudicial to the safety or interests of the state, and that was an objective test. And at that stage, you had a statement, and it was from the Deputy National Security Advisor, dated the 22nd of November 23. So that's what you had. And the statement essentially said this: it proceeded on the basis that it would be proved by others that Berry had been recruited by the Chinese state as an agent, that he passed information from Cash to Berry, et cetera, all of that stuff. So he goes through all of that material and says, this is the material, this is how it was getting to China, this is who the people were who were getting it. And then the important thing, the original evidence that he gave, which you didn't get from any other source, was the evidence about the guilty mind, which was he made clear that the information was of the type passed that would be prejudicial to the safety or interest of the state, and he repeated that throughout the statement, right? So he's proving the guilty mind, others had proved the guilty acts, and what you didn't have in that first statement was you didn't have any evidence that China was an enemy, right?
We felt that, I mean, the high watermark of his evidence was his statement about the capability of China.
Are you referring to page 2, paragraph 6?
Yes.
Yes.
If I may I read it out?
Please do. Does it begin, the Chinese intelligence services are highly capable and conduct large-scale espionage operations against the UK and other international partners to advance the Chinese state's interests and harm the interests and security of the UK.
That's it.
So that's it. So you had that, but you had no more to prove at that stage that China was an enemy, right?
That was the basis upon
Right.
which we felt that we could
And the
maintain
law
the case.
at the time there was no definition within the Official Secrets Act as to who is an enemy, and these cases don't come up very often. And there had been this case called Parrott, which had come out before the First World War, which tends to show just how often these cases come up, which is not often. And in Parrott, what was said was that the law at the time was that Parrott said enemy is not defined, right? But that an enemy can be a country that one day might be at war. We might be at war with, which just makes sense given it was the year before the First World War. So again, very vague, but essentially saying we're not going to say what enemy means. So that's your law at the time. You've got that one statement saying that the Chinese intelligence services are capable and conduct large-scale espionage operations, etc., etc. So that's all you've got. And what you're doing, aren't you, when you charge them, is you're thinking, right, we have these different elements, we're going to leave it to the good sense of a British jury to decide whether or not China is an enemy. At that stage, when you were charging, that was what your thinking was, wasn't it?
Well, at the stage we're charging, we had actually already begun and ultimately were successful a case based on threat to national security. And that's the case of Rousseff. I've referred to the legal ruling, but of course it was a criminal case. So...
I mean, sorry. No. When you're charging the case, you charge on the basis of the law, right? And the law is what I've just taken some time to bring everybody through, which is the statute and a case called Paris, and that's the law at the time, right? You may be sorting out another case that may or may not go to the Court of Appeal. It may or may not make some law. You don't know at that stage. When you're charging on the date that you did, right, which was April 24, you did it on the basis of the law then, not the law that you hoped might come at some stage in the future. You do it according to the law then.
Yes, but
right.
We took the view in both cases that the enemy requirement could be satisfied by demonstrating that the state, in one instance Russia, in the other instance China, was a threat to national security. And so that's the basis upon which we proceeded in this case.
I mean, you might have taken the view that you had evidence that China was conducting large-scale espionage operations against the UK and had recruited a couple of people who were connected with the British Parliament, and that by itself might be enough to persuade many a juror that China was an enemy, because it's hardly the behaviour of a friendly country.
The basis upon which we took the decision to prosecute was that. But what happened was that when in the earlier case, Rusev, that approach by the prosecution...
No, I will give you a chance to move on. I just want to get the basis of this clear.
Yeah.
Because what I don't understand, you see, is that if you had enough evidence to charge, why you didn't have enough evidence to carry on with the case,
yes,
and what it was that changed.
Yes.
And you say that the law was fundamentally changed by the case of Rusev, which made your evidence that you had when you charged not sufficient.
No, I'm not saying that.
If
I may, can I just finish my explanation? Yeah. So the case of Rusev did confirm that you could base a case on the threat to national security posed by another state. But what it did was to also say that if you're basing a case on threat to national security, then you have to demonstrate that at material time it was a current threat. The difference that Rusev made was that we needed to demonstrate in terms that the totality of the threats posed by China during the period of the offences made China a threat to national security. We weren't quite there on our existing evidence, and so we asked for more. We asked for a positive statement from an expert in this area. The DNSA wasn't giving evidence as an individual. He was drawing on all the resources available within government to produce his evidence. So we're asking him for that bit more. But it turned out not only to be a sticking point, but to be a critical difference.
But before we move on to the evidence that you got, or you didn't get when you tried to get more, I just want to know the basis upon which you were deciding that you needed to get more evidence. As I say, there might be many people, ordinary members of the public, who would be bringing common sense to this, this event through a jury, who might think large-scale spying on the UK, by China looks like the actions of an enemy to me.
Yeah.
So what changed it, you say, was Rusev. But don't you agree that the Court of Appeal said that it wasn't going to, this is in the case of Rusev, that they weren't going to establish a new meaning of enemy, that the term enemy should be approached in a common sense way? Now, lawyers know common sense way means that's why we have juries, because juries have so much more common sense than lawyers, frankly. And we need to get the jury to have a look and decide whether or not someone is an enemy. So Rusev is specifically saying we need to approach the idea of what is an enemy through a common sense way, i.e. we need to ask a jury. So we say that neither the approach in Parrott or Rusev was laying down a comprehensive test. They said that as well, as if you hadn't got the message from you need to ask a jury. They're now specifically saying we're not saying what a enemy is. Another country would be an enemy if the jury concluded that it was a country that Britain might one day become at war at. Well, obviously you weren't claiming, nobody was ever claiming that in relation to China necessarily, or maybe you were. Presumably you weren't. There was no reason why the term enemy should not also include a country that represents a current threat to the UK national security. That's also include. It's not this is the only way in which a country can be an enemy, is if they in future might be at war, or they represent a current threat to UK national security. They were specifically saying we are not saying what the definition of enemy was, so you should have just gone ahead and prosecuted it.
Well, I'm sorry. Absolutely, they were saying that there wasn't a comprehensive definition. They confirmed that you can bring a case on the basis that a country poses a threat to national security. But they defined the ambit. If you're going to bring a case on that basis, they defined, as you've just read out, that there's no reason why you can't bring a case on the basis that at the material time it was a current threat to national security. So obviously, were to offer to us, it felt that